All rise. Veuillez vous lever. Please be seated. Veuillez s'asseoir.
We have to issue the following decision. The Chamber is satisfied that Mr. Ongwen understands the nature of the charges. Mr. Ongwen confirmed to Pretrial Chamber 2 that he had read and understood the charges as set out in the document containing the charges at the confirmation hearing. As Mr. Ongwen said back in January of this year, and I quote, "Thank you, Your Honor. Well, from my point of view, whether the charges are read or not read is all going to be a waste of time. You may speak 5 words and only 2 issues are correct. You may speak 10 words and only 2 things are correct. The reading out these charges, whether they are true or not, is all going to be a waste of time. I've been handed out the document translated in Acholi, so I've read and understood it. Thank you." Quote end. Other information before the Chamber also confirms that Mr. Ongwen understands the charges. First, the charges that Mr. Ongwen said he understood in January are not materially different now. All 70 charges alleged by the prosecution were essentially confirmed. The confirmation decision has been fully translated into Acholi specifically for Mr. Ongwen's benefit. The Chamber is not persuaded that Mr. Ongwen cannot understand something now he so clearly understood back in January. In this context, the Chamber is also satisfied that Mr. Ongwen has been fully informed of the incriminating conduct since the confirmation of charges decision set out the facts of the case with precision, together with their legal characterization. Lacking further substantiation, and in light of Mr. Ongwen's own admission at the confirmation stage, the Chamber is unpersuaded that Mr. Ongwen, at this stage, does not understand the nature of the charges as foreseen in Article 64, paragraph 8a of the statute. Second, and as mentioned earlier today, the defense gave no indication that Mr. Ongwen was having difficulty understanding the nature of the charges or the proceedings more generally. Quite the contrary, the defense has made several arguments such as requests for Acholi translations, reinforcing that their client did understand. Third, the Chamber cannot help but note that Mr. Ongwen's alleged lack of understanding comes just after his defense team alleged it has evidence supporting the notion that he is not fit to stand trial. As stated previously, the Chamber has not received sufficient substantiation to conclude that Mr. Ongwen is unfit. In particular, the expert reports which purport to prove the defense's position have not been provided to the Chamber. The Chamber nevertheless notes that, in describing the expert reports, the defense says the experts conclude that Mr. Ongwen, and I quote, A, does not understand the charges, quote end, and B, again a quote, was not aware of the wrongfulness of his actions during his time in the bush. The former statement is a legal question experts cannot determine at the expense of the Chamber, for it is the Chamber who has the final decision on whether Mr. Ongwen understands the charges. The latter statement, on its face, is less about unfitness and more about Mr. Ongwen disputing the legal characterization of his alleged prior conduct. Mr. Ongwen's remarks today are no different. Mr. Ongwen's remarks that the LRA is not him and that the LRA committed these acts demonstrate an understanding of the confirmed charges. Mr. Ongwen's remarks are rather a dispute as to Mr. Ongwen's responsibility for these alleged acts. And this is precisely a matter to be discussed during trial and is not properly part of an Article 64, paragraph 8a determination. For these reasons, the Chamber is satisfied that Mr. Ongwen understands the nature of the charges. We will now proceed, and Mr. Ongwen, please rise again. Now, Mr. Ongwen, do you make an admission of guilt with respect to any charge?
Your Honor, I haven't responded to your question. I have a question first. I would like to inform you that I'm very happy because when I was initially brought here, this is the international court. When I was in the bush, I had people talking about the International Criminal Court. For these reasons, I should have started by crying and just surrender. If there's anything that has to be done, let them go ahead and do it. First, I would like to ask you if the court would grant me permission. This is a division of death and life. In my opinion, this amounts to my going back into the bush for the second time. The International Criminal Court, do you agree? Do you agree that I'm the leader of the LRA? Do you agree that my life was not ruined?
You are here before a court, and you are not in the position to ask the court questions. You are in the position to make submissions via your counsel. You will receive a fair and impartial trial. And you may, if you want, answer the questions that the court puts to you. And I would ask you to answer the question and repeat it. Do you make an admission of guilt with respect to any charge?
In the name of God, I deny all these charges in respect to the war in northern Uganda.
You therefore plead not guilty with respect to all the charges, I assume.
Yes.
As stated previously, in Decision 449, the Chamber set a deadline of 28 October 2016 for the filing of any motions requiring resolution prior to the commencement of the trial. The Chamber subsequently ruled on all requests received on or before this date, and with this morning's oral decision, has in fact ruled on all pending requests at this time. However, and noting Rule 134, paragraph 2 of the rules, the Chamber will now ask the parties whether they have any remaining objections or observations concerning the conduct of the proceedings, which have arisen since the confirmation hearings. Be mindful that, in accordance with Rule 134, paragraph 2, no such objection or observation may be raised or made again during the trial proceedings without the leave of the Chamber. I first ask the prosecution, please.
Mr. President, no objections from the prosecutions.
For the defense,
May I please, Your Honors? We've carefully listened to the decision today, and want just to say that in the course of the proceedings, we expect that specificity be given to us in respect of some of the charges, which mean, with regard to venue, Northern Uganda, within a period of 5 years, is so huge. So we hope that we'll be raising the question of specificity as the proceedings proceed in order to have appropriate notice of some of the charges. We will raise it as the occasion arises in the course of the trial.
Yeah. Thank you very much. It is now time for the opening statements. We are shortly before the 11 o'clock break, so I would even ask Madam Prosecutor if you would prefer to start after the break.
Perhaps, Mr. President, that would be best, so that we can continue and have more time to make the full presentation.
Caroline, can we then have it? Okay. So we resume then on 11:30.
All rise. Veuillez vous lever.